Right, we are at 10 a.m. Get started here. Welcome and thank you for joining us today. We are very excited to share this information with you. My name is Christine Drasher. I am with Cassia and one of your hosts for today's event. I am joined with my colleagues, Shelly Kruger and, my slides aren't advancing here, and Craig McDaniels, also from Cassia. A couple housekeeping points I just want to bring to your attention. We do have over 100 participants today, which is really exciting. Just due to the sheer numbers of people, we do know that you're going to have a lot of questions throughout the presentation, and we'd like you to remain muted just so that it's a little bit easier to manage, and we'll be using the chat feature on Zoom for questions. So that usually is on the bottom of your screen or under the options on the top of your screen. So Shelly and Craig will be moderating the questions on the chat room, and we will address them throughout the presentations with Mary Frances. We will be providing handouts of today's presentation for everybody who participated. You will be getting an email within 48 hours of the presentation, along with those that are in healthcare and might need a certificate of education. We will be providing that as well with the email afterwards. Our goal is to record this. Hopefully we don't have any technical difficulties. We will record this and have this available also on the Cassia website for you to go back and view again or share with others that might be interested in the information. All right, so we're gonna get started. Just, I wanna spend a few minutes just discussing or sharing with you Cassia and what Cassia is, what services we provide. And so I have a short video here that we're gonna share with you to get us started.
There is something special about Cassia. A spirit you feel everywhere in our communities.
I am compassion.
I am integrity.
Yo soy la unidad.
I am unity.
I am collaboration.
I am innovation.
I am stewardship.
I am respect.
I am excellence.
I am Cassia.
I am Cassia.
I am Cassia.
We are Cassia. We are Cassia. We are an extension of your family. In the same way, we treat you as an extension of ours. We are here to be caregiver, companion, chaplain, housekeeper, nurse, so you can be the daughter, son, grandchild, spouse your loved one needs.
This is the spirit of compassion you'll find everywhere at Cassia.
To us is a mission.
Technology can heal, and we are working towards state-of-the-art. But technology cannot care. We all love a beautiful facility, but the warmth a building gives its occupants doesn't replace the warmth of a human touch. Our focus at Cassia is on the dignity, health, well-being, and spiritual care of senior adults. At the heart of excellence that sets a Cassia community apart is a staff working for a purpose larger than themselves. Caregivers who value the lives our residents have lived and bring value to all that comes next as their life story continues. Independent living, assisted living, skilled nursing, transitional care, memory care, adult day, home care, hospice care, spiritual care. Our range of housing and care options is wide because we know the need is great. Our tradition of providing excellent care has been the work of generations. The name Cassia is new in senior services. When Augustana Care and Elam Care came together in 2018, we chose a name from biblical times to signify our faith tradition. It's an ancient word that once meant servant's heart. Today, it stands for our goal of unmatched care and service. We invite you to visit our communities. Experience for yourself the full life a spirit of compassion makes possible. Cassia, an Augustana Elam affiliation, serving all by following one.
All right, I'm going to pass it on to Shelley.
Yeah, that's a video is a great synopsis of what we do and offer at Cassia. Offering just a bit more here, this gives you a good look at our location guide. And please note, we'll be including this location guide at the end of the presentation, and that'll be included in that slide deck that's emailed to you. So as you can see here, in the video it was referenced that there's a combined 215 years of experience providing housing, healthcare, community-based services to older adults. And we serve those folks in 5 states currently: Colorado, Florida, Iowa, Minnesota, and North Dakota. So residents and patients and clients can find independent and assisted living communities, memory support, enhanced care suites, adult day services, rehabilitation, and skilled nursing at Cassia. And we have the privilege now of serving approximately 9,000 folks in senior housing and skilled care. We also partner in ownership with independent and service providers such as Centrix Therapy, Pro Rehab, Grace Hospice, and Guardian Angels Home Care and Hospice. Cassia owns additional service lines, positioning our organization to be a full service provider, a one-stop shop, if you will. Additional service lines include A&E Pharmacy, a medical supply company called Elam Preferred Services, and assistive technologies through the Cassia Learning Lab.
All right, Craig.
Yeah, good morning, everyone. My name is Craig McDaniels, and thank you for attending part 1 of our speaker series with Mary Frances Price. Just a word about this slide here. You know, if you are considering making a move for yourself or helping a loved one or even making a referral, we ask that you consider a Cassia community. In these times of COVID-19, we are fully transparent at Cassia, and keeping your loved one, our residents, and our staff safe is priority number 1. Just a word about moving process at this time. You know, during COVID-19 right now, we have many different protocols in place. If a new resident is making a move to one of our communities right now, they would quarantine for 14 days. Only testing if your loved one is coming out of a transitional care unit or the hospital. Also, we are slowly starting to open our dining rooms, our beauty salons, that kind of thing, with the proper social distancing and PPE. Next slide. And then just a reminder, if you haven't already, if you haven't already signed up and do have an interest, we've got part 2 in the series coming up here on July 22nd. And again, this slide deck will be provided to you for more information. And also part 3, veterans benefits for long-term care on August 5th. And again, we're glad you're here. Thank you for attending, and look forward to a great Q&A today too.
All right, thanks, Craig.
You're welcome.
All right, so we're going to get going with introducing our speaker and moving forward with our presentation today. Just a quick reminder though, again, because of the number on this call, if you can please mute yourself so we don't have any background noise, and also use the chat room feature for questions throughout the presentation here. So So I'm excited to introduce Mary Frances Price from Long, Rear, Hansen and Price. Mary Frances and I have worked with for many years, probably over 10 years, she can probably clarify that, doing presentations out in the community. And every time I hear her, I learn something new. She's just a wealth of knowledge. As you can see here from her bio, she is a shareholder at Long, Rear, Hansen and Price. She went to Mitchell Hamlin College of Law, received her undergraduate degree from Purdue in Indiana. She's licensed to practice law since 2005 and has counseled and advised hundreds of clients on their estate and elder care plans. She focuses her practice on serving individuals and families who are establishing an estate plan, revising an estate plan, or dealing with legal, medical, and financial impacts of aging, chronic illness, and disabilities. She is accredited to practice before the Department of Veterans Affairs since 2008 and has counseled many veterans and their families in regards to VA benefits. So please welcome Mary Frances today and enjoy her talk. Thank you.
Thank you, Christine. Happy to be with everybody this morning and excited about our new platform. As Christine said, we have been engaging with members of the community, mostly through senior centers, churches, and other community-based organizations. So once COVID hit, as most of us are having to redefine how we connect with people. So we're really excited about the new platform that we're using and getting acquainted with. So our topic for today for part one is estate planning. And what we're really talking about is the basics. What I hope you take away from today is just some good, solid information that'll get you thinking about the plan that you already have in place and maybe need to review, or if you haven't put a plan in place, maybe start thinking about doing that. This presentation is not a substitute for, engaging with somebody who can really help you customize a plan, but it's intended to give you a good foundation of information and things to think about. So when we're talking about building an estate plan, there are some basic components that everybody should either think about or have in place. And so what I'm talking about here would be financial and health directives for lifetime incapacity planning. So lifetime, of course, meaning while you're living. So sometimes people think of estate planning as what happens with my property after I die. And certainly that's a component of a good estate plan. But what we're seeing that is even more important, or as important, I should say, is thinking about the possibility that I'm alive, but I'm not able to manage my own decision-making. And that can be decision-making around financial and legal decisions, or it can be related to health and wellness. The word incapacity is a word that lawyers love to throw around, but it's actually a clinical determination. So incapacity is something that is determined by a physician, and lawyers use it a lot in documents to signify whether or not somebody has the ability to make their own decisions. So the concept of thinking about what happens if I'm alive, but I'm not able to make my own decisions is a really big area of estate planning that any thoughtful plan would have addressed. Then there's your testamentary plan. Testamentary, again, another word that just means final disposition of property. Okay, so a testamentary plan could include something like a will. It could use a revocable trust. These are all things we're going to talk about today to hopefully give you a better understanding about what that actually means and what might work for your situation. Also important would be beneficiary designations. So this is something that is not necessarily part of a will or a trust, but it should be properly coordinated with that will or trust. So many of us are familiar with the concept of putting a beneficiary on a life insurance policy or maybe a retirement plan. And we're going to talk about today with specific examples what can happen if those beneficiary designations or ownership arrangements don't match your will or your trust. It can cause an outcome that you didn't plan for. So your estate plan should include all or a combination of these three things. So first, we're going to take a look at the financial directives for incapacity planning. And in this situation, we can advance, Christine. There are a number of arrangements that people use or that I see or people evaluate in the course of planning, including informal arrangements, different ownership arrangements like joint tenancy with right of survivorship, the use of a document called a power of attorney. Some people turn to the use of a revocable or irrevocable trust. And then also there's something called conservatorship, which is a judicial action. If you're outside of Minnesota, another word for conservatorship might be guardian over the property. This is a concept that you have a judicial order that allows someone to manage the property and finances of another person. So this is our roadmap of where we're going. And we'll start by looking at informal arrangements. So what I mean by this is some people, as they're aging or managing chronic illness or disability, they may ask for the assistance of a child or another trusted person in their circle. And so it might include something like allowing a child to have passwords to bank accounts or online accounts. And so that may work for some period of time. And you know, I have families where a child is really wanting to continue to honor the parent and wants them to be engaged in the financial management. So they may make an appointment once a month to stop over, and they're going to write out all the bills and the checks and balance the checkbook. And the child may write the check out, but then they'll turn the check over and parent will sign it. Children also can, you know, be present and then call something like the Social Security Administration, and the parent's sitting right there on the speakerphone, and then the parent gives authorization, but really the child's doing most of the talking, is oriented to what task needs to be accomplished. So these are all examples of informal arrangements. However, you can see they may work for some period of time, but they're really not a comprehensive solution for long-range incapacity planning. I've had circumstances where adult children have all of the online passwords and access for a bank account, as an example, but then the bank by policy will prompt somebody to renew their password and go through a series of security screening that maybe a child couldn't pass because they didn't know the keyword. So they contact the bank and try and explain, well, I'm the child of a parent with advancing dementia, and I'm just trying to update the password. I've had it for 4 years. As you might imagine, the bank is not going to be very receptive to that type of inquiry because they're trying to protect their banking client. So these types of arrangements just don't work when somebody has advancing incapacity. So to have a proper plan in place that's really effective, we have to look beyond these informal arrangements. So naturally, over the years I've been in elder law practice, I get a significant amount of questions like, should I add my child to my bank account? Or even from my own mother, should I put you on the title of my house? So these are common questions. There's a lot of information out there in the public domain. People say in circles, you know, if you add your child to your bank account, then it keeps it out of probate. Or maybe then if you go to the nursing home, if your child's on the title of your house, then the nursing home can't get your house. So these are all thoughts that people talk about. And Christine, if you can go to the next one. So ownership arrangements can include, a commonly used ownership arrangement is something called joint tenancy with right of survivorship. An example of that would be most married people that own real estate take title to the real estate as joint tenants with right of survivorship. And what that means is that if you have 2 people on title and one person dies, that the surviving person is the 100% owner of that property. That can apply to things like houses and cabins. It also applies to things like automobiles, bank accounts, and other financial accounts. So people naturally think, oh, maybe I'll add a child as a joint owner because I've heard that's a good thing to do. However, there are some risks associated with that. So if you add somebody as a joint owner and that somebody is going to file for divorce, bankruptcy, or maybe is underinsured on their automobile, gets in a terrible accident and is being sued for negligence, then if that person is on a bank account jointly, then the entire amount of that account would be subject to these these situations. So, it doesn't work with the bankruptcy court, for example, to say, that's not my money, that's my parents' money. They just added me as a joint owner for their own convenience, but really, because legally, any joint owner has an interest in that property. So the other limitation to be mindful of is, I used the example of my mom asking me several years ago, should we add you to the title of our house? To which I said, well, if my mother added me to the title of her house, and then she decided years later that they wanted to sell, then not only do I have to consent to the sale, but since I'm a married person, even though my spouse is not on the title, he would also have to consent to the sale. So this concept of it limits your ability to manage that asset without the consent or involvement of the other person. And it can also be something to just hit the pause button and say, do I really understand the full implications of adding a joint owner? Probably the most common challenge I see with adding somebody as a joint owner is that it can completely unravel an estate plan. So somebody has a will, and their will says how their estate is going to be divided, but they bring somebody on as a joint tenant and they don't really understand how that impacts the overall plan. So let's take a look at a specific example to illustrate this. So my example is Sam, a widower with 3 adult children. He really intends for his estate to be divided between or among his 3 surviving children. He has a house valued at about $150,000, checking and savings accounts totaling about $150,000. And Sam has a will that says at his death that each of his children should get 1/3 of what remains of his estate. So Sam is expecting, right? He is expecting, I love these simple numbers. You could tell a lawyer put this together, right? $300,000 total estate, 3 children. He is intending that each child gets an equal share of that remaining estate. However, this winter, Sam had a neighbor who was out shoveling and fell on the ice, fractured a hip, went to the hospital, received a new hip, and after 4 days in the hospital was transitioned to rehab for 2 months. And during that journey, Sam was watching the neighbor's children get involved and try to make sure that the house was maintained, that the bills continue to be paid. So he decides, hey, if that happens to me, I'm going to add my son because I want him to be able to have access and still continue to manage my affairs if something like that happens to me. So it's a well-intended thought, but here's that the act of adding his son as a joint tenant actually causes his estate plan to be, unraveled. So he is thinking $100,000 each because that's what his will says. However, when he added his son as a joint tenant, that meant his son gets 100% of the remaining money in the bank at his death. So what actually happens is each of the kids, in my example, would receive a 1/3 piece of the proceeds from the sale of the house. The entire amount of the cash accounts in the bank would go to his son. So you can see this is an unequal distribution of his estate. Even though he has a will that says 1/3, 1/3, 1/3, keep in mind, joint tenancy assets are not governed by what your will says. So joint tenancy, I used to say trumps what a will says. Now I say supersedes. It's a lot more politically correct. So a joint tenancy arrangement supersedes what your will says. So here we have a situation where one child gets a lot more than he had intended. Let's think about if his will said 10% to Mount Olivet Lutheran Church, okay, or his favorite charity. 10%, and he's thinking 10% of 300,000 is 30,000, and then the remaining 170 divided equally. Well, what would happen here for that charitable beneficiary is they would only get 10% of the probate estate, which is the house. So only 10% of the 150. So there again, the act of adding the joint owner completely unraveled what his intention was. Now, Stephen, his son, could he equalize that? Could he write out checks to his sisters to equalize the distribution once he realizes? Yes, he could, absolutely. If he writes an equalizing check to each of the siblings and it's more than $15,000 in a calendar year, he has to be sure to report that as a taxable gift. So there would be some other additional formalities that may result from that. The point here being that that act of creating the joint tenancy caused there to be an outcome that Sam didn't really intend. So if informal doesn't work, joint ownership has some things to be cautious about. Well, then what do we look at as an alternative? And so this is where I would have preferred to see Sam have a power of attorney in place or use a revocable trust. So here, power of attorney, this is a legal document, okay? It's a legal document that allows somebody over 18 who has capacity to appoint one or more people that they would trust to manage their financial and legal decisions. Okay, so power of attorney is only related to somebody's legal and financial interests. It has nothing to do with their healthcare decision-making, except that the person with the power of attorney is the person who might be responsible for paying the health-related bills. So the concept here is somebody with capacity can write out a legal document saying, here is who I trust to manage my legal and financial decisions for me in the event I'm alive but incapacitated. So powers of attorney can be very specific and limited, or they can be very broad and general. An example of a specific limited power would be about 5 years ago, my husband and I were closing on a piece of real estate. He got called up for jury duty on the day of the closing. He could not get out of jury duty. I needed to attend the closing and sign off on the transfer of title for the two of us. So we executed a power of attorney that was limited for that one day, specifically for the purpose of allowing me to close on real estate. The next day, that power of attorney was no longer valid. However, in elder care planning, we're usually looking at something that would be broader and not time limited. So a power of attorney that does not expire, that we don't know when it's going to be used, because we're planning for the potential that the principal, the person who signs it, is going to be incapacitated or may need some supported decision-making during lifetime. So one of the things to look at if you have a power of attorney is it limited in any way? Is it time barred? Does it expire after a certain point in time? The majority of powers of attorney that we see are, they are live once they're signed. Okay, so once they're signed, they could be used. There's an exception to that. There's something called a springing power of attorney, and springing means that it only springs into action or becomes effective typically upon written physician certification of incapacity. So an example would be a few years ago, I was working with a client who had lived out, she was from Minnesota, she lived out east for probably 40 years for her career. She was moving back to Minnesota after a dementia diagnosis to be closer to family. She had never been married and didn't have any children, and she was going to be asking some other family members, nieces and nephews that she was acquainted with, but didn't have a super close relationship with. She was going to be asking them to be appointed in her power of attorney, but she was concerned about the potential that somebody might intervene in the management of her affairs before she was ready. So we added some springing language that said something like, this document shall be effective once a physician who has examined me certifies in writing that I'm no longer able to manage my financial affairs with adequate competence. So then once the person named in the document obtains that written opinion of an attending physician and attaches it to the document, then they'd be able to use it. So it's a way to put in kind of like a gatekeeper to allow her to feel comfortable, like somebody wasn't going to intervene in the management of her affairs before she was really ready. Now, even with springing language, somebody could voluntarily resign. It doesn't always have to get to the point where a physician needs to certify incapacity. We hope, and it's common, that some people will just decide to voluntarily resign or ask for the assistance of their named agent. So the principal is the person making the document. The attorney, in fact, that's the person or persons that are appointed in the document. So sometimes you see people sign Mary Frances Price, POA. And POA is really referring to the piece of paper. But if I am appointed in a power of attorney, I am appointed as an attorney in fact, or AIF. Okay, so the power of attorney refers to the document. So powers of attorney can be durable or non-durable. In elder care planning, we typically want to see a durable provision. Durable means that it endures incapacity, which is precisely why we're doing planning in the first place. We're planning for the potential that somebody becomes incapacitated, needs support with their financial and legal decision making. So durable just means that the document continues to be valid or effective or usable even after the principal is unable to make decisions or give directions. So right out of our Minnesota statutory form, there's some language here. This power of attorney shall continue to be effective even if I become incapacitated or incompetent. That's a durable provision. That's very common language, not just in our state, but across other states as well. So in order for it to be considered a durable power of attorney, it would incorporate language to this effect. So in our state and in many states, there are two primary forms of a power of attorney. There's something called a statutory form. Statutory just means that if you looked it up in the law books, you would see a picture of exactly what it looks like. That is by design. And that's so that everybody can recognize it very easily. So it looks a little bit like a boilerplate form. It's set out in the statutes, at what it should look like, how it should be completed. And I think that's where, sometimes people think, well, I can do that. And maybe they can, but if it's not filled out correctly, or if you're not really understanding what the effect of checking this box is or leaving that blank, it's important to really understand how it's completed. So there's this temptation that it's very easy to use. It is, and it might be, but you want to be careful with how you're filling that out. One of the advantages of a statutory form is that many states that have them also have some laws around enforcing their ability to be used, or of like the bank to accept it as a valid document. Our statutory form, and many, you can elect whether they're durable or not simply by checking a box. And again, in elder care planning, the overwhelming majority of documents, if not all, are durable. And that's because, again, we're planning for the potential. We don't know when, we don't know how, but we want that power to be vested in the person or persons we have trusted and appointed. The second document is referred to as a common law power. Again, our state, many states have a statute that says if it's not a statutory form, then it's a common law. The reason we may have both is it's a lot easier to operate with a document that everybody recognizes right off the bat when they look at it. However, it is very limited in what it can be used for. So if you've ever seen a statutory form, a lot of them have like a checklist, and you can check off all of the above, and it may say something like banking transactions, real estate. And so built into the law are some limitations. And when we're doing advanced planning, we may require broader authority of the person being appointed. We may want to go broader than the statutory form, in which case an attorney may recommend to you the use of a common law. And it's not, and some people, I've had clients over the years say, well, why don't we just do the common law? Why do we have to have both? Well, 95% of the time, the Minnesota statutory form is going to be a lot easier to operate with because people generally recognize it. However, there are some advanced planning, options and or certain, like for example, I've had clients who own property in Florida. Florida does not allow you to use a Minnesota statutory power to transfer title to real estate that somebody in Florida may own. You'd have to have what's called a common law, which has broader authority. It's also signed in the presence of 2 witnesses and notarized. So there are a number of reasons that people may need to have both of these forms. And then a few of the reasons also I've given you on the bottom here: to create or manage a revocable trust, changing or viewing beneficiary designations. And then again, the gifting authority is a big one, particularly for people who are concerned about how they're going to pay for long-term care expenses, and whether or not they have a document that will allow them to manage the full estate. So to give you a specific example, I was working with somebody in the last week who has a spouse with advancing memory loss and is intending to apply for some county-based benefits, and it would be advisable to remove the spouse from the title of their home. And he does not have a power of attorney that will allow him to do that. So that's a very specific example of where even a spouse of 45 years who owns a property jointly, who's really needs to do this planning to access funds in order to pay for necessary care, has a power of attorney that's way too limited and doesn't give him the permission that he needs in order to remove his spouse from the title of the house. So when you appoint somebody, you can appoint, one person and then a successor, a first successor, a second successor. You can appoint 2 or more people together. If you appoint 2 or more, you must specify, are they required to act jointly, or may they act independent of one another? But keep in mind, when you name somebody, it's a nomination. So that person is not legally obligated to accept the nomination. Example, I had a client who named the child, 10 years ago when they did their power of attorney that they thought would be in the best position to help them. Then fast forward 10 years, at the time client was needing that level of support, that particular child had lost a job, was going through a divorce, and was having some health challenges of his own. So that was a case where we needed to roll to the first successor. So even though the child was still living, the child was still capable of serving, the child refused the nomination in favor of the first successor. So remember, you're not legally required to act if you are named in a power of attorney. However, if you accept the nomination, then you must be prudent. You must act in the best interest of the principal at all times. You must keep complete records. If the document requires you to render an accounting at an interval, it could be annual, semi-annual, or quarterly, then you have to be prepared to do that. And if somebody uses a power of attorney in bad faith or to cause financial harm, then of course there may be civil or criminal penalties under the law in the state where that document is governed. So when we look at financial abuse cases of a vulnerable adult, typically it's committed by somebody with a valid power of attorney acting in bad faith. So it reminds us that while these documents are essential, it's really important to make sure you understand what you're doing when you fill that document out, who you're nominating, what authority you're giving to that person or persons. Are there checks and balances built in? I just had somebody sign a document earlier this week that required the person who's acting as the attorney-in-fact to send an annual accounting to the financial advisor who has agreed to receive those annual accountings, to review them, to make sure there isn't anything that looks out of place. So there are ways you can build out your document to make it effective and safe. And certainly it's preferred over the alternative of not having a document, but you do want to exercise some caution when you're completing these. The temptation to just fill it out, check the boxes, and then have it in place. As I said, the majority of cases involving somebody committing financial abuse of a vulnerable adult is somebody who has a valid power of attorney, but used it inappropriately. So just to kind of summarize, thinking of SAM, and the advantages and disadvantages of a power of attorney. Christine, if you want to move to the, thank you. So remember, Sam, who's sitting here, he's trying to be responsible. He's trying to be thoughtful. He's a widower. He has 3 children. He's thinking about the possibility, what happens if something happens to me? I would have preferred over the joint tenancy appointment of his son on the bank account that he executed a power of attorney. Some of the advantages are they are easy to get in place, relatively, right? This is one of those documents where I do think making the investment with an attorney, a licensed attorney, to have it done correctly is a sound investment. Why? I've seen people fill their own out off of LegalZoom or other formats, and they don't really understand what they say. And in order to fix that problem, in some cases, it's a lot more expensive than it would have been to just do it correct on the first go. So they're easy to put in place. They're relatively low cost. What do I mean by that? Well, compared to the alternative, which is something called conservatorship, we're going to touch on, which is a judicial action. So a lot of times people will say, well, what does a power of attorney cost? It varies widely. I'd say between $150 and $750, depending on if it's a single person, married couple, and whether or not you need just the statutory form or if you need both the statutory and the common law. So that gives you kind of an idea of the type of investment. And again, it's the type of thing that, in contrast, a conservatorship judicial proceeding can be, $3,000 to $10,000. So when I say low cost, I'm comparing it to the alternate path. Powers of attorney are revocable, meaning, you can put one in place today. 3 years from now, you might be looking at who you've appointed and think, oh, I'm not sure that that's the best arrangement today. I'm going to revoke this and update it, make a new one. Again, powers of attorney are enforceable. So when we come up against challenges like a bank or somebody is failing to accept the appointment, we have a body of law behind us that we can say to the person refusing to accept it, there are enforcement laws that have to be honored. It's an appointment of somebody to step into your shoes and to conduct your affairs with the same force and effect as though it were you. The disadvantages, of course, it's subject to abuse. This is not something that a court is supervising. It's a private contractual arrangement with the persons you've named in the document. So there again, there's nobody overseeing it. We can build in those checks and balances like requiring an accounting. In general, I say, if you can't, feel fairly confident or totally 100% confident that the person you're naming will use this authority only in your best interest, then we have to talk about, is that the right person, right? Because there are also professionals. I have many clients who some don't have any family, some have family, but they're not really interested in having that person have this level of authority. We might look at alternatives like naming a family member, friend, or professional, in recognizing that this is, vast authority potentially that you're giving to someone else. And again, the other disadvantage I touched on is that just because you name somebody in the document doesn't legally require them to serve, which brings up another point, which is that if you're thinking about this important planning and who you might choose to ask to help you, if you're in a situation where you need supported decision-making, it's a good idea to talk to the people you're thinking about, okay? And it sounds like a simple thing, But particularly in Minnesota, where, we like to believe everybody's above average, and, we all live in Lake Wobegon, right? This, perfect little world. Nobody really loves to talk about death, incapacity. What does it look like if I, become incapacitated and need help? But going through that exercise, I think, is really important. Because you're also gauging somebody's interest level. The other day I was talking with clients who have 3 children, and they were, sorry, I just lost my video here. So they were trying to decide which child in which order would serve. And I said, well, have you ever talked to them about it? And, it kind of like blew their minds, like, oh, that didn't occur to me. And I said, I think it'd be a really good idea. And these were all adult children in their 30s and 40s. And I said, I really would recommend that you just have a conversation and say, here's what we're thinking about. We thought it would be, you, because you live in close proximity to us and you live in Chicago. And I said, but, sometimes you learn some interesting things in talking with even your own children about what their comfort level would be in taking on these different roles. So I think, it's always a good idea to do that if you can. So in another alternative, again, thinking about Sam, thinking about his options on how he can get his affairs in order, another option may have been the use of a revocable living trust. Now, there are attorneys out there, there are financial professionals who will try and tell everybody across the board, you should have a trust. That is not my feeling or position. I think trusts can be really effective planning tools, but it's not something that I would say is universal and should be used by anyone under all circumstances. So revocable means it can be changed or altered. Living means that it was established while the person is alive. Another word for that you might hear is inter vivos. That just means during lifetime. So a revocable living trust is one that is created during lifetime. So for example, let's say Sam thought, I don't want my kids to have to go through a probate proceeding at death. I own a home and I have bank accounts. What's an alternative to having a will that would require a probate? Sam might establish a trust agreement which would spell out how his property is to be administered and used while he's living. It would also address how his property is to be used if he's alive but lacks capacity. And ultimately it would say, here's what I want to have happen with my remaining estate at death. Okay. And so when somebody establishes a trust and moves their property into it or coordinates their beneficiary designations properly with the trust, then it's a very effective tool to bypass a probate proceeding. Now, probate has somewhat of a negative connotation. It's really not a horrible thing, certainly not in Minnesota. It's just a judicial process that after somebody dies, to prove that a death occurred, to identify the remaining property of the decedent, the person who died, to find out whether they left a testamentary instrument, a will that says, here's how I want my estate divided, and then ultimately to pay off creditors and distribute property according to the person's will. So, it's like a final accounting for somebody who has died, and it's court supervised. Now, the reason some people don't prefer it is because it has statutory timelines. So for example, when a probate is opened under Minnesota law, it must remain open for 4 months to allow creditors to make a claim against the estate of decedent if that person who died owed them money. So some people find those statutory timeframes really annoying or off-putting, and it's a process, and it's not a process that takes 2 weeks. Right? It's typically months, sometimes years if we have family members that aren't, getting along. So the alternate option to a probate might be the use of a revocable trust. We're also seeing that people like Sam, who are recognizing his own potential for incapacity, right? He saw his neighbor fall. He saw his neighbor go to rehab. He's recognizing his own potential vulnerability, and he's thinking about how he wants that to look if he's alive but needing assistance. And so we're seeing more people use revocable trusts as they're thinking about aging and incapacity or disability planning. Sometimes I have people who come to me after having done a lot of work with another attorney, maybe 10 years ago. They come in with a fancy binder and they say, we established a trust and here it is. And I'll say, okay, well, can I see a schedule of property that's in the trust? To which I'll get a blank stare, like, what? Well, I thought since we signed the trust, that means all my stuff is just magically in it. In fact, that's not how it works. Signing the trust is step one. Then you have to sign, for example, if you own a house, a deed that transfers title of the house into the trust. If there's a condo in Florida, you have to have a Florida deed drafted that puts that house in the trust. Same would be true for bank accounts, investment accounts. There are certain assets that can never, never, never go in a trust, like an IRA, a SEP, a 403B, 401k. Those are retirement accounts that must remain in your name alone. So I put on my slide, may avoid probate if funded correctly and with coordinated beneficiary designations. Okay. Remember I touched on that at the outset, how important you can have a beautifully drafted trust or will that says how you want your property distributed and who's in charge. But if you have a life insurance policy, as an example, that says, payable to my oldest child, then that asset is not controlled by your will or trust. So those beneficiary designations have to be coordinated with your testamentary plan, with your trust, with your will. And so that's probably one of the most common errors that I observe when I'm working with people on estate planning, is they come in with beneficiary designations that say one thing, and then an intention in a will or a trust that says something totally different. So sometimes it's just as simple as taking a look at those two things and getting them to match up. And so, just signing a trust, right? Just signing a piece of paper does not avoid probate. There are these extra steps that need to be observed. And so because of that extra formality of having to manage the title to assets and the beneficiaries, that's why I say the use of a trust is not appropriate for everyone. There are some circumstances where we may say, ooh, we should consider trust planning here. One would be property ownership in multiple states. Okay, why? Well, if I have somebody who has North Dakota farmland and lives in Minnesota with a house, if they die, there would be a probate proceeding in both North Dakota and in Minnesota, 2 probates. So that's a circumstance where we might say, ooh, this person could benefit from having one Minnesota revocable trust into which we put the North Dakota property and the Minnesota property, thereby bypassing the need to have those probate proceedings. So property ownership in multiple states, sometimes with second and third marriages, trust can be very effective to allow for example, if I have somebody who has children from a previous marriage that says, if I die, I want to make this property available for my spouse while my spouse is living, but then after my spouse dies, I want that property to go back over here to my children from my first marriage. How do I do that? Maybe a trust would work to help keep that type of plan in place. Of course, we use trust for certain types of tax planning and planning around incapacity. So supplemental and special needs trusts are commonly used for people with beneficiaries that may be disabled. Adult children with MS, other children who have a disability that parents want to leave money and property for, but they don't want to do it in a way that would harm their receipt of medical benefits that might be asset limited or means tested. So those are some of the examples of when trusts might be used or employed. And as I said, commonly with people who are planning for incapacity. So think of Sam. He's a single guy. He has his home and his bank accounts. He might be thinking, what happens if I have to move to assisted living and I want to have my property managed for my benefit? I'd like it to avoid probate. I want my son to be the primary decision maker with my daughter as the backup. You might be able to do that through the use of a trust. So Christine, if you can go to the advantages and disadvantages. So it avoids probate if it's set up correctly, and if those beneficiary designations are coordinated and the title to assets are conformed with the trust. It can be used for tax planning. It may shorten the settlement time of the estate. Why? Well, remember I said probate has these statutory timelines that have to be observed. In a trust, it's a private administration. So you don't have those same time requirements. It may provide immediate income to the beneficiary. Why? There again, it's already been established, it's funded. The successor trustee after the death of the original trustee or grantor can take over and continue paying bills, making distributions. So that takes less time than a probate. And again, may provide some guidance or knowledge for the successor trustee on how to manage the estate outside of a judicial proceeding. So disadvantages, I think some people think, well, I've done this trust plan, so then after death, there's no expense, there's hardly anything. There still will be expenses. A trust plan is typically more costly in the planning phase and then less costly after death to administer, but anytime somebody dies, there will be expenses associated with managing their affairs after death. One of the disadvantages, again, is that supervision of the asset titles and updating if you need to make changes. You still have the possibility of mismanagement by a trustee, just as you would with a power of attorney. You still have the cost after death, of some final disposition of the trust. And probably the biggest consideration is there's no cutoff time frame for creditors. So in a probate, remember I said we have this 4-month period where we say creditors come forward, and if you have a claim against the estate of decedent, make it known now. And if you do not within that time frame, you're barred from recovery. Well, we don't have anything similar in a trust administration because there's no requirement to publish notice to say to the world, did this person died, did they owe you money? So sometimes we're cautious when we use trusts in a situation where we are worried about insolvency. And insolvency is the word for there are more creditors than there are resources or assets in the estate. And it's something like that I might say to my client, if we have a lot of creditors out there, it's safer to be in a probate. So those are the types of decisions that you want to make alongside your trusted counsel in figuring out which one makes the most sense for me. So we've talked about informal arrangements, joint tenancy, and different ownership arrangements. We talked about powers of attorney. We have touched on revocable trusts as an alternative. So what happens when none of these things are in place? A few years ago, I had a gentleman and his only child, an adult child who was a professional. They were very, very close family. This particular person and his wife had lived at home for many years together, and he was a primary caregiver for her with advancing memory loss. And she had never received a formal diagnosis of memory loss, but one day she had a terrible fall and was transitioned to the hospital. And through the hospitalization and rehab, the memory problems were exposed and accelerated and through this journey. And ultimately it was determined that if she were to come back home, it was going to need to be with substantial supports in place, probably 24/7 skilled care. Family decided that's not financially feasible, so the decision was made to move mom into skilled care. This was a day that the family had planned for, right? Mom and dad and adult daughter had planned for this. They had owned a couple of rental properties that they intended to sell one and then use the proceeds from the sale to pay for the nursing home care. So they came in to see me because they even had a buyer for one of these properties. It was a neighbor. They were ready. They had drawn up a purchase agreement when they realized that both of the mom and dad would need, husband and wife would need to sign off on the sale of that property. There was no power of attorney in place. And this was at a point where the spouse who was in memory care was so advanced, she didn't know who her family was. She didn't know what a pen was. She was totally incapable of holding a pen or signing a document or directing somebody else to sign on her behalf. It would have been totally inappropriate for her to sign a power of attorney. So the only alternative we had in that case was to petition the court. This happened to be in Hennepin County, Minnesota. We petitioned the court. Everybody agreed, right? Dad, daughter, they just agreed this was the right way to go. They still were required. Dad had to have an attorney. Mom had a court-appointed attorney whose job it was to make sure to report to the court as her advocate whether or not she was incapacitated. So the court appoints an attorney who interviews mom at the nursing home. My client had me representing him through the proceeding, all so that we could get a court order that says you can go ahead and sell the house, okay? And that process, uncontested, okay, took weeks, probably 4 to 6 weeks to complete because it was not perceived as an emergency by the court. And then the lawyer needed time to go out. We all had to have time to draft our pleadings. As you might imagine, that process uncontested, I don't remember, probably $3,500 to $5,500 and required a court appearance and court pleadings and so on. Dad also got the bill for the court-appointed attorney after the proceeding. So you can see that's a process most families want to try to avoid. If you've ever seen the word incompetent, okay, that we use a couple words in estate planning: incapacity, which is a clinical word that's determined by a physician, and incompetency. The only way somebody can be deemed incompetent is by a judge in a court of law. And that's what happens in a conservatorship, which is over somebody's property and finances. And there's a companion proceeding called a guardianship that we're going to touch on. So, you know, when I've been involved in this type of court proceeding, even when it's uncontested, it's upsetting, right? It's upsetting for families. It's not your choice anymore, and it's going to require in most cases, some ongoing supervision by the court over the management of that incapacitated person's affairs. So now we're going to shift. That was the majority of our time. We're talking about, again, legal and financial directives, okay, and also testamentary documents, those wills, that trust. Now we're going to shift into legal directives for healthcare decision making.
Mary Frances, do you think maybe we could answer a couple of questions before we
Sure.
move on to that?
We have one here. I'll read a little bit of background here for you, Mary Frances. When my mom died and we moved Dad to a location here, we sold their house a few months later. The closer noticed their home was, instead of joint tenants, was tenants in common. This was a surprise, and no one had a guess why. They were talked into this years ago. Mom's half of the sale of the house then went into probate for several months. Isn't tenants in common mainly for people who own a business together? That's the first question. And it would be smart for people to check to see how the title to their home is. It ended up costing $4,000 to settle that those legal fees.
Right, so thank you for that. Joint tenants with right of survivorship, we talked about, that's the most common way people that are married take title to real estate, which is, you know, we both own it, and that if one of us dies, the survivor gets all of it. Tenants in common, think about it as a pie, right? Two halves of the pie. One spouse has this half, one spouse has that half. This spouse dies, their half is subject to a probate. It doesn't automatically go to this spouse. It might go to that spouse if they have a will that says, give it to my spouse. But in any event, tenancy in common means you have two pieces that can be severed. They're separate. Joint tenancy is together. So tenancy in common is typically seen in arrangements where maybe siblings co-own property. So think about the cabin that descends from mom and dad to 3 children, and each of the children may want to have their severable 1/3 share that they can give to their family at death, and not have it just go to their siblings through joint tenancy. So tenancy in common is a different designation. If it doesn't specify on the deed, then the default presumption is tenancy in common. Okay, so you really have to understand, if you're looking at real estate interests and co-ownership arrangements between spouses, between siblings, between multiple generations, and yes, in business arrangements, you want to understand, how do I own this piece of property? Because that will have significant effects on how you structure your estate plan. So does that answer the question, or do we have any others that you wanted me to address at this time?
No, there are no others at this time, Mary Frances.
So we'll move into our last slide here. We're shifting gears away from the money, away from the legal decisions. Similar concept, I'm alive. I need help making my decisions. How do I communicate these decisions if I'm unable to do so? Who do I trust to do that? There are many different types of medical directives. I'm just going to touch on the 2 most common in our state. In Minnesota, we have a document called a healthcare directive. Some states have a healthcare power of attorney and a living will. What Minnesota has done is taken a healthcare power of attorney and a living will and combined them into one document that we call a healthcare directive. Healthcare power of attorney is a designation of who you trust to make health-related decisions. Anytime you are after age 18, if you become incapacitated and you can't communicate with your providers, your healthcare directive or healthcare power of attorney gives you the ability to appoint that person. Living will is specifically focused on end of life. So once somebody is deemed terminally ill, who can make decisions or communicate decisions about their end of life preferences, following the wishes that are stated in the document or otherwise known to them by the appointed person. So there again, different states handle this a little differently. Our state, Minnesota, has that healthcare power of attorney living will combined into one that we call a healthcare directive. Healthcare directives must be signed by a patient with capacity. They must appoint 1 or more persons. Again, you can have multiple people. If you do, you need to specify, must they act jointly? May they act independently? It can include instructions about healthcare and treatment preferences. It may include guidance for somebody on end of life preferences. Keeping in mind that a healthcare directive, to be valid, is either signed in the presence of a notary or 2 witnesses in Minnesota, but it is not a medical order. It is not a medical order. So if somebody's healthcare directive said, I don't want CPR, they, and somebody has a cardiac arrest in their home and EMT come into the home, you can't hand them a healthcare directive that says the patient doesn't want CPR, because it's not a medical order, okay? It is, and so it cannot be relied upon in those acute end-of-life situations. Because of that, years ago, the Minnesota Medical Association embraced a document that is referred to as POLST, P-O-L-S-T. This is an acronym for Provider Order for Life-Sustaining Treatment. And you can find these forms online. If you go to the Minnesota Medical Association, if you talk to your provider, not everybody under the sun needs a POLST, but there are circumstances where people could really benefit. Persons living in senior housing, persons who are hospitalized, somebody who would need to communicate efficiently what their end-of-life treatment preferences are, should consider having a POLST. This is a document that is signed by a patient and their provider. Provider under Minnesota law means an MD, DO, APRN, or physician assistant. Okay, so it has to be signed by the patient and one of those providers, and it is a medical order. That's important because then emergency responders can rely on the do not resuscitate, do not intubate provisions. So for example, I had a client several years ago, age 96, living independently in the community, still driving a car. She said, Mary Frances, I've been blessed with long life. She said, but if I'm found at home and it's clear that I have died and I've been dead for some time, she said, I don't want to have CPR. I don't want somebody to call 911 and to have aggressive medical treatment that would serve no purpose for me at this point in my journey. She said, I've accepted that could happen, and I want to make sure that my intentions are clear. So she had a POLST order drafted with her provider that she kept on the front of her refrigerator after contacting local emergency responders to find out from them, where would you look for an order like this upon entry into her home. She also lived in a condo complex, so that had a reception area, so she also had a copy of that available at the reception area. So there's an example. And so senior housing, if you're living in senior housing, this might be a really important thing to think about. Why? Because in the context of a medical emergency, a healthcare directive might be 8 pages long and might talk about your preferences for care and treatment and end of life. But again, it is not a medical order. And in the context of an emergency, we need to have a very efficient way to communicate how the emergency responders should respond in accordance with the patient's wishes. When we have a situation where there is, even sometimes when there's a healthcare directive in place, or where there's no healthcare directive, this is typically when there's one surviving parent and maybe multiple children who have different ideas about the healthcare decisions for an incapacitated parent. So when there's a complete absence of any guidance and the family's not getting along, okay, and the family's not getting along. If families are in agreement and they don't have a healthcare directive, they may still be able to effectively direct care for someone. Where it becomes a problem is when there's a divergence of opinion about children that have equal legal authority. So one child thinks mom would want everything and anything to try and keep her alive. Another child thinks, I don't think mom would want to live it like this with this quality of life. When there's that kind of a disconnect and there's no healthcare directive and you've got multiple people with equal legal authority, that's where a guardianship proceeding may come in. Because if decisions need to be made, first of all, in that case, it will always default to the most conservative course of treatment, which is typically preserve life, okay? So if there's a question about what a patient would want or does want and the patient can't communicate, it's always going to default to the most conservative course. Guardianship, again, in Minnesota, guardianship over the person is a court proceeding to ask the court to appoint someone who would be in charge of making decisions that are in the best interest of the person who's nominated for guardianship. This is a process, again, can be costly, time-consuming, involves the judicial determination, and so a lot of this can be avoided with proper planning, using a healthcare directive, possibly a POLST, but in any event, typically I've never been involved with a guardianship where people were happy about it. It's something that's imposed because it's a last resort. So it's not an effective way to plan for health-related decision-making. Keep in mind, healthcare directive isn't just end of life. It's also things like, where's mom gonna live? Let's say mom has dementia and she needs to move out of her home. The healthcare agent named in a healthcare directive is the one who has legal authority to sign an admissions contract, placing mom in memory care in the nursing home. So I have a little magnet over here in my office that a client gave me years ago that says, be nice to your children. They may be choosing your nursing home. And that's true for the child who's named in the healthcare directive as your primary agent. So for today's purposes, I've gotten through the content I wanted to cover. I'm happy to answer any additional questions you might have.
Mary Frances, Craig here. We do have another question for you. My dad passed away in May. If my father left everything in his will to my mom, and we agree with that, do we still need to go through probate? They only have 2 joint bank accounts and no property.
Okay, so what did we learn about joint tenancy? Joint tenancy means mom and dad are joint, dad dies, mom's the surviving joint owner. That's not a probate asset. So my answer to that would be, if it's true joint tenancy property and mom survived, there would be no need for a probate under that circumstance.
Thank you. Another question. If all appointed persons on a healthcare directive select to not accept guardianship, is the only option left, how can this be avoided?
So if I'm understanding correctly, there's a healthcare directive. It appoints certain persons. All of those persons have declined the nomination. So in effect, there's nobody available to make decisions for the person who executed the healthcare directive. Here again, if decisions need to be made, a guardianship is a possibility. And then the question is, who petitions for the guardianship? I mean, guardianships are not a foregone inevitability. Sometimes there are other mechanisms in place in long-term care communities. They'll go through their bioethics review teams to figure out, is there an alternate way? Because here somebody has clearly articulated, care and treatment preferences in a healthcare directive, but they just have nobody who's available to serve. So is a guardianship a possibility? Certainly would be, but there may be some other lesser restrictive means that could be investigated. It's going to depend on where they are, what type of decisions need to be made.
No other questions right now in the chat.
Okay.
Here's one that just came in. If both spouses have a long-term care policy that always claims to cover what seems like a couple $1,000s a month, less than the current nursing home fees, how does Medicaid work? If a 5-year look back has been thought of, is a revocable or irrevocable trust necessary?
So Faye and James, thank you for that. You definitely want to attend part 2 because I will spend an entire hour to hour and a half examining the Medicaid medical assistance program, addressing things like the 5-year look back period. There is a 5-year look back period in Minnesota. So, that session is 100% intended to address the question you're posing here, which is how to build a long-term care payment plan. Recognizing that some people may have things like long-term care insurance that would cover 70%, but there's still going to be a gap. How do we do that? When does Medicaid come into place? That's a broader conversation than I can have right now, but I do want to address your last question, which is about the use of a revocable or irrevocable trust in Medicaid planning, because Minnesota is a state that does not recognize irrevocable trusts for Medicaid planning. In fact, we're the only state. It's something that our National Academy of Elder Law Attorney chapter here locally, where we've got an effort ongoing to talk with the legislature about how this is not in step with federal law. But currently, our state does not recognize the use of an irrevocable trust as a means by which you can protect property. There are some legal ways to do that, but you have to use extreme caution if you're talking about irrevocable trust, because we have a statute that bars that, or it just essentially says that Minnesota just totally ignores federal law. And if you have an irrevocable trust, it's considered available property to you. even if it's actually not. So here again, that is a good question. It's layered with lots of stuff that I would love to talk about, and I will talk about in a couple weeks. So I hope you come back and join us.
All right, Mary Frances, another comment. Isn't a long-term care policy a good idea, mostly better for couples? This helps protect the spouse's assets who stays in their home. If I understand, if a person goes into long-term care, the couple must spend down exactly half of their assets to pay for the person's care before they can have medical assistance take over.
So let's start. Is it a good idea to have long-term care? That's really a highly individual decision. It's something that I do spend time talking to clients with, financial advisors, accountants, attorneys. Those are all good resources if you're thinking about investing in that type of product. You do want to make an informed decision. It makes a lot of sense for some people. For other people, it's not an appropriate way to utilize resources. It may help protect one spouse. So if one spouse gets ill and you've got a policy that's infusing, $2,000 to $5,000 a month into the monthly budget to help offset the cost of care, then it can be greatly helpful. It slows the draw on other assets or resources of the family that would help be available for the well spouse who's continuing to live in the community. The spend down of half assets, that is not the law in Minnesota anymore. In our session 2 weeks from today, I'll go through the eligibility rules, but we no longer have this concept of splitting the estate and spending down half. Now Minnesota has gone to something called a bright line standard, which just means here's the amount of assets. If you're above it, you have to spend down. If you're below it, you're immediately eligible. So there have been some changes as of 2016 in Minnesota's Medicaid program in terms of how we determine eligibility. And I promise you, if you attend, you will have a very good understanding of what those rules are and when medical assistance would kick in, specifically in the case of a married couple where one person has high care costs and the other person's still living at home.
And Mary Frances, the question comes from a couple from the state of Maine.
Oh, okay. Yes, I see that was Faye and Jim.
Yep.
I love Maine. I have a family in Brunswick. Glad you can join us.
Okay. Another question. If I have a joint ownership on the bank account for my mom and all her money, will be divided at death. What was the comment on taxed as a gift? I came in late and did not hear the outcome on that.
So issue number one, if you're a joint owner on account with mom and mom predeceases you or dies first, then you are the sole owner. Even if you want to divide that evenly among surviving other siblings, for example, you can do that. But if the amount that you gift to a sibling exceeds the IRS threshold, which is currently $15,000 in a calendar year, then you'll have to report that on a gift tax return. You're not probably going to pay taxes on that because each of us has a lifetime gift exemption of $11.4 million. If you make a gift over $15,000, it just needs to be reported on your lifetime tally towards that 11.4. So it may not be a problem, but my example that I was talking about earlier is it creates an inconsistency when Sam was thinking, my will says this, but the act of joint tenancy, totally altered that. So you do want to be mindful of joint tenancy property, because if you're the surviving joint owner, it's all yours. Even if you're thinking, well, this is mom's money, I'm supposed to divide it according to her will. Technically, her will does not control that.
No other questions, Christine, at this time.
Wonderful. Well, thank you, Mary Frances. Again, I learned so much from listening to you. So
Yeah.
thank you so much.
Christine, we do have another one coming in.
Oh, well, go for it.
Sorry.
No problem.
Okay, So it's good to it's good you let people know it's better to be a POA for your parents rather than have your name on their bank account. I heard once also that if you're a co-owner on your parents' account, if one of you is ever sued, the both of you will be. Is that true?
You may not be sued, but certainly the property that's in that account would be subject to attachment if there was an order establishing that either owner had some liability. So in other words, you can't be sued if you didn't, if you weren't a party to the action, but the property may be at risk. The jointly owned property may be available to satisfy the creditors of the person who is being sued. So I think your point, what you're saying is correct, which is, there are these other liabilities that are created. So you might be thinking, oh, this is just purely for convenience. But if somebody's getting a divorce or filing a bankruptcy or being sued, those are risks that you are assuming of your joint owner. So, and then that property may be at risk, even though you're thinking, I'm the one who contributed all the money to that. My child didn't put any dollars in there, but they own it just the same as you.
Mary Frances, there are a couple more here. What things are not to be in a trust? Some things cannot be owned by a trust. What are those items?
So, tax-deferred retirement assets cannot be titled in trust. That may include investments like a 401k, IRA, SEP, SEP, 403b. This is alphabet soup, but the idea being those are special investments that when you put $1 in, you don't pay income tax. And then it gets to sit there and grow for some period of time. And then when you turn 72, you have to start taking dollars out. And then what happens is you pay income tax at that time. And those assets cannot be owned by your trust, which is why the beneficiary designations are really critical if you have that type of investment.
Thank you. Another one, do you need a will if you have beneficiaries on all assets, or is there a benefit to have a will as well?
So good question. Beneficiaries, you can put a beneficiary on an automobile, a watercraft, a house, a bank account, a life insurance policy. So the question is important. It's what if I just put beneficiaries on everything? Well, let's talk about that. I'll use an example. I had a client with 3 surviving children. She put beneficiary designations on everything, including her home and automobile. Every child gets a third. Very efficient, avoided probate. However, after death, what happened was the death certificates issued. 1 child lived locally, 2 lived out of state. And what happened was it was the middle of winter, she died. The person who lived locally called me and said, the life insurance, the retirement account, the bank, it all went out a third. And she said, but there's a property tax bill coming due. We need to keep the essential utilities going on this house while it's pending sale. I'm probably going to need 6 months to deal with, the clearing out of personal property and prepping the home for sale. She said, who's going to pay for that during that time? I said, well, technically all 3 of the property owners should contribute equally. Those are the expenses of administration. She also said, I got a last ambulance bill. I got a bill from the, funeral home, etc. How am I going to get, and she said, I paid for the funeral. It was $10,000. She said, how am I going to get that money back from my siblings? I said, well, you can ask. Well, one of her siblings was totally, compliant and, was willing to pay a third of the utilities, was willing to do this. The local child was left holding the bag on the 1/3 that the other child just refused and said, I don't have the money. I need it for myself. I'm in financial hardship. So here they co-own this house. There are expenses of administration, including taxes, bills from the last ambulance trip, medical bills, funeral bills. So 2 of the 3 kids ended up shouldering all of the expenses of administration because she had done this all beneficiary plan design. So if you're, I'm not saying never do that. What I'm saying is if that's your plan, you must also think about how are we going to address expenses of administration? Because I've seen that, that's just one example. I've seen that happen repeatedly. And as you might imagine, after death, sometimes people behave differently, especially when they start inheriting money and they start getting into these, you know, sibling co-ownership situations. In contrast, if that had been part of a probate estate or part of a trust estate, there would have been one person, either the personal representative executor or the trustee, who was responsible for pooling all of the money, for identifying all of the expenses, clearing up the property, listing it for sale, paying the gas and electric and the property taxes. And then once the property was sold, it all goes into a pot. Everybody has shared in the expenses of administration, and then you can distribute the proceeds equally. So just be careful with that all beneficiary design. Can it work? Yes, it can. But there are these, just think about after death. There are details that need to be sorted out, and who's going to be responsible for that. There's no decision maker in that case. You really have to have beneficiaries that are willing to communicate and work together, which you may have, in which case it may be effective.
Christine, do we have time for one more?
I think we can, yes.
Okay, I know we're running tight here.
Yep.
One more, Mary Frances. So if I have a power of attorney and I am joint owner, I should take my name off as joint owner?
So this is where I have to be really cautious. I don't want anybody to run out and make sweeping changes today based on what I'm saying. I'm giving you some baseline guidance, but in terms of giving you specific guidance, I really don't want to do that because I could bring more harm on your situation than good. So that is a really good question, but it's one that you definitely want to make alongside your trusted advisors. So not trying to be evasive, but there are these circumstances where if I made a blanket statement and everybody ran out and removed themselves as a joint owner, there could be other pieces of the puzzle I'm not aware of, and I don't want to cause you to do something that could actually bring harm upon you. So really, I can't underscore enough, as I said at the outset, we definitely, this is intended to be like community ed friendly and give you a laundry list of things to think about, to review your own plan, but ultimately you definitely want to get good advice that's specifically tailored to your individual needs.
Sounds good. Well, thank you so much, Mary Frances. You are a wealth of knowledge. We look forward to having you back in a couple weeks. Again, if you haven't registered for the next couple sessions, please do so the same way you registered for this. And handouts, and for those that need a CEU certificate, we will get those out to you within 48 hours. If you do not receive that, feel free to email me. My email is right there at christine.drasher@cassialife.org. So thank you so much for everyone, Shelley, Craig for helping out, and Mary Frances, and have a great rest of the day.
All right, thank you.
Thank you.
Thank you.
Take care.
Bye now.
Bye.